SJC-13122, Commonwealth v. Averyk, Carrasquillo.
Okay. Attorney Renaud.
Thank you, Your Honors. Can you hear me?
Yes.
Suzanne Renaud for Averyk, Carrasquillo.
Yeah, actually, yeah, just
much louder.
Thank you.
Much louder.
Your Honors, this case came before the lower court as an issue of consent, but obviously the predicate question is whether there's privacy attaching to social media. And it's a newish technology. The judge below, the approach would basically say that nobody who is operating in a social atmosphere would ever be entitled to any kind of expectation of privacy. I think there's a better approach to that. What these social media companies have in common is, irrespective of their terms of service, or if they're like Snapchat, which is ephemeral, needs to have a lot of notifications based on video, and it's a little bit more akin to oral communications, or it's more traditional like Facebook, is that they divide themselves into two different kinds of categories, public and private. And those words have meaning to the users. The users look at that. If it's public, it means that the posts that they put are available to anybody to see.
But counsel, I understand the conceptual argument you're making, but isn't there testimony that the defendant in this case really didn't pay too much attention to his public or private, or at least he didn't get it right, because he admitted a friend that wasn't really his friend. He didn't know him, and he really didn't know what his settings were.
Well, Your Honor, that is a factual question. I think I was just wanted to frame the issue initially, but the point that is made there, whether or not he knew this person was a friend, let's put it this way. If you were having a house party and you were letting people in and you invited 10 people and one of your friends brought a friend, all you have to do is say, can that person come in or can they not come in? You don't have to scrutinize their bona fides. It's not the job.
Now, suppose that friend is an undercover cop and sees something illegal at your house.
Well, Your Honor, that's an issue of consent. The question is there, you have the right to say that your home is private. And if you've consented, if it's legitimate consent to the police officer coming in, that's a question of consent.
You don't know he's the police, he's undercover.
Well, that's the ruse. And the questions of ruses always indicate the issue of consent.
So a police officer undercover cannot go into another's home without consent, knowing that they're undercover?
Your Honor, that's essentially what a ruse is. It's saying that you have consented to let that person in to see usually it has to do with some kind of criminality that you're engaged in, but that is absolutely the case. It's that when you're dealing with the ruse, it's a second level question. You already have that expectation of privacy surrounding you. They have to get consent. Now they can use trickery. They can't go over the line to coercion, but they can use trickery to gain that consent. But that is a second question that comes after the question of whether or not you had an expectation of privacy in that area to begin with. And so
does that apply outside the home?
I'm sorry?
Have you found cases where that's applied outside the home? Here we're talking about a social media electronic platform, sure. And you're saying that space is like a home.
Yes.
And I'm wondering if there's any support for that proposition, given the way that the home is so unique for search and seizure cases.
Well, I could think of two cases that both the Commonwealth and I cite. I think we both cite them, the Hines case and the Kaup case. Both of those have to do with computer networks. They're not social media networks, so they obviously are different in kind. But in both cases, the police received consent from one of the authorized users to be able to get into that network. So even though the information was being shared among a network of people, and in the Kaup case, it was an entire school, they had to get the consent to come in. So yes, it would apply. That same principle would apply even outside of a home. If I was having a private party at a hotel, that would also apply. If I was sending, if I was sending an email to 50 people because it was a Christmas letter, the police can't get into it just because I sent it to other people. So that's not a case, it's just an example, but there are certainly cases out there that say that consent is necessary even when something is being shared. Did that answer your question, Your Honor?
I think it did.
Ms. Renaud, you give us an attractive option to basically rule based on private or public settings, which would be easy to apply. But when you wrote your brief, you didn't have the benefit of Delgado Rivera.
That is true, Your Honor.
Okay, so we go to Delgado Rivera and we look at that case, and the text message in that case certainly was private. So your private public kind of falls apart, but what doesn't fall apart is the discussion in footnote 7 about ephemeral message in expectation of privacy. Can you reframe your argument or give me an argument regarding that footnote 7 and why that applies in this case?
About whether it's ephemeral. Well, I would say, Your Honor, the
About
question,
why there's a reasonable expectation of privacy in light of what we wrote in Delgado Rivera.
well, I certainly will. And the issue in Delgado Rivera, and it's one that was identified by the Commonwealth in the DC Circuit case that they cited, and other cases that you say, well, there's no expectation of privacy in this thing that they lost control over. But I would say that, Your Honor, that logic is actually just kind of shorthand for a greater picture context that you've provided. Because in, if you give me just a moment, on page 1561 in Delgado Rivera, you don't just talk about that in a vacuum. You say that there is a risk that the confidant will reveal the information that frustrated the original expectation of privacy, making something that was once private now into something that was public. When you frame the issue on page 559, you said this was the issue of the sent text message being captured by the police officer. So the issue there isn't just, when you're talking about this third-party consent or assumption of the risk question, you're not simply talking about it just, oh, you just don't have any expectation of privacy, period. That's never how we framed the law. If you were to frame the law that way, we wouldn't have any expectation of privacy in anything that we ever sent. And so what you are actually talking about is that the police can go to a friend and see if they'll, quote unquote, rat out the person in question, or they can get a search warrant for a friend and get the question. But it is not hypothetical or theoretical that will happen. It's something that has actually happened. So in that sense, I don't think Delgado Rivera changes the situation, the expectation of privacy at all in any of this. It is not material whether you share with 50 people, 100, 1,000 people within your social network, because unless the police actually get the item from that person, that principle of assumption of the risk simply does not apply. And that is the case in the United States. I'm sorry. Here,
the police tried to capture the Snapchat and they couldn't.
Well, Your Honor, this is that issue about the police actually trying to capture the Snapchat came after they purported to get consent. But the question that the way the Commonwealth and the judge below framed it is that they didn't even have to get to the point of asking for consent because there was never an expectation of privacy.
Right. So, I mean, your case might fall into footnote 7 of Delgado Rivera. I guess the bigger issue that you have as far as the judge's findings are her first findings regarding no subjective expectation of privacy. Is that supported by the evidence, or why is that clearly erroneous?
Well, Your Honor, I would say there are two things about that. First, the way I wanted to make sure to frame a social network, and I just want to get this out there, is that social networks, when we're talking about private ones, is that there's a circle and there's conversation inside of that. And that the defendant is, or the user is the gatekeeper.
It's like the circle of trust.
Essentially, yes. And Commonwealth
to
versus
quote Robert De Niro, but go on.
Commonwealth versus Flood says that you are supposed to be able to share with others, groups of people, and be able to keep the government out. And objectively, so we have that sense of it meets the legal definition. And objectively here, not even based on Mr. Carrasquillo's testimony, but based on Officer Conley's testimony, and that's why I'm trying to bring it back from that for a moment. He said that I saw Frio Fresh existed. I couldn't see any of the content. I made a friend request. He said something happened, which we know from common sense and from Snapchat's terms of service is that the user actually has to be the gatekeeper and let him in. And then I could see everything. So on the day he was seeking consent, we objectively had a private account. This court in Commonwealth versus Mora suggests that you can extrapolate, even without much else on the record, that somebody who has an objective expectation of privacy would also have a subjective expectation of privacy, in part because it's based on their conduct. If their conduct shows that they had a private account on that day, why wouldn't they also have a
Counsel, well, can I interrupt you with one question on that? So when we're looking at the expectation of privacy and you say, okay, if you walk, talk, and act like you want this to be private, how does that square with just accepting friend requests from folks that you just don't know? So when you're talking about marrying the two concepts, and now there's another point to that. I know somewhere in somebody's brief, they talked about the fact that you could have a really big wedding and it wouldn't convert it into a public wedding. But by extension, if you have an account owner who's just indiscriminately accepting folks into this circle of trust, And now it's 1,000, 2,000, 3,000. At what point does it become absurd that you say that you have a circle or an expectation of privacy in what you're sharing with these folks when you don't legislate who comes in because you're letting in people you don't really know? And it could arguably grow to a point of just an inordinate amount of people that are in this private setting.
So what I would say to that, Your Honor, is where do you set the line? So that would be a problem, a legal problem of where is that line going to be set? Is it 50, 100, 500? What number is too
Well,
many?
let's start with the first question about just indiscriminately allowing people into that pool.
Well, I would say to that, Your Honor, if it is a private account and if Blood says that the point is that you're supposed to be able to keep the government out, if it's not indiscriminate, I mean, in this case, we do have at least some evidence. And going back to Justice Gaziano's question of, did he say that, he didn't let the police in? He said he didn't let the police in. It's not completely indiscriminate. The whole point is to say, oh, we're just not going to let the police in. And this is an undercover officer who didn't identify himself as a police officer. If that was the case when you have 50 or 100 or 500 friends, that's the only point of factual information that I think that you would need to know, because otherwise it's not the court's job to be scrutinizing how well we know all of these people.
It may not, but this is important here. Let's just presume for the sake of the argument that what you're doing or you're posting, is illegal, like taking videos of flashing guns that you don't have a lawful right to possess. So irrespective of whether or not this person is an undercover police officer, you're letting folks in that you don't know to see stuff that arguably could be illegal.
Well, the problem with that approach, Your Honor, is at what point do you have to make that scrutiny? Because what—
Well, wait. Suppose you, as an attorney or just a person, came upon the account and took a fake name and signed on. That's fine, isn't it?
That is a very different situation.
Why?
Where
Why?
That's the United States versus White, frustration of purpose. I've already brought people in, I'm assuming a risk, but risk is actually coming to pass that a person who I'm friends with is going to end up sharing it with the police.
No, but
Or
this
that-
is different though, because he's sharing it with the person he intended to share it with. This is different from Delgado in that sense. Whatever this person's name is, he deliberately sent it to him.
Well, that's a question
And
of—
Roos,
I'm sorry.
you're going to ask us to overturn all of the Roos cases?
Certainly not, Your Honor.
Okay, well, so
But
how do
I'm
we?
saying that factually here, so what you're pointing out, Your Honor, is that, he consented to let this officer in. So that comes a question, that second question.
He
that I
consented to
wanted—
let this person in, and he has, and again, we're measuring a subjective expectation of privacy, right? So he's not someone who keeps his circle of trust close. He's showing someone he barely knows that he's engaging in illegal activity. Does that reflect that he
I have a
has?
problem with that approach, Your Honor, because you are presuming that it's his burden to show that he had to keep it close, because that's how the judge
His
below
burden—
addressed the
I
question.
thought
And-
it's his burden to establish an expectation of privacy,
But
right?
if he has established that that the account itself fundamentally is private, the account itself is private because only people in that circle that he lets in
But
are
wait, there's
private.
another step here. Is it private because he took an affirmative step to make it private, or does Snapchat just default you to private?
I don't know that that matters,
I
Your Honor.
I think, why
I think
not? Why not?
He did, in fact, have a private account, and it is also defaulted to private. Both of those things can be true.
But the problem is the judge made findings that are contrary to you.
But not on that point, Your Honor. Not on the point of whether or not she discredited what he said.
Right.
But if you look at not his testimony, but Officer Connolly's testimony, that is clearly a private account on the day.
Oh, no,
of the incident.
there's no question it's a private
Okay,
account.
Your Honor.
And that's why you're first.
So as far as her discrediting him, I mean, as I noted in the reply brief, there are certainly many issues that are involved with, I think the reason why she discredited him are based on some misreading of some of the facts.
So we have to dive into that to see if it's supported by the evidence or if it's clearly erroneous, rather. But your other argument is that we should look at more in some of the other cases and assume a subjective expectation of
There is
privacy.
that. And, I feel like I'm running out of time and I haven't even addressed the consent issue. I mean, with Mora as well, I just to throw this out here, I know that the Commonwealth cited Mora for this purpose. If you did not find that he had a subjective or objective expectation of privacy, under the mosaic theory, you could certainly find that sitting on an account for a month using this unlimited technology would create an expectation of privacy, which would also beget the need to make sure that there was consent and that this ruse was not done inappropriately. But I just wanted to mention one thing on the ruse question, because obviously it's the Commonwealth's burden, and I don't believe that they supported that with sufficient evidence. But there's also a question of reasonableness of the use of the ruse. And Pagan-Gonzalez, which the Commonwealth cites, also cites to Lefebvre, which says this is about a consent to a ruse to see something criminal. There was nothing criminal in this case. The government was just using the ruse for an unlimited general search, a fishing expedition, if you would. And I would say to even get to the point where they're allowed to use that very, very powerful law enforcement tool with no suspicion is also unreasonable under the circumstances.
So are there, again, just so I'm trying to understand, are there cases that say that ruses can't be used by police unless there's reasonable suspicion of criminal activity? I'm just trying to get a sense of
Thank you, Your Honor. I just want to make sure I cite to the correct case here. Lewis at page 211 suggests that there has to be a specific limited purpose. Pagan-Gonzalez at footnote 9 cites to Lefebvre, which is just, it's not a case, but it is something that you might look at that says that there has to be, that there is a choice to expose your criminal activity to other people. And if you look at all of the cases, the ruse cases that are cited in my brief and the Commonwealth's brief, every one of those cases in the Commonwealth has a connection to some kind of criminal activity.
But they're going to be because they were arrested.
But I would say
right?
that
Because I mean, cops can't basically dress as meter readers and knock on doors and say, hey, can I come in? I got to check the meter.
which is exactly what they're doing right here. They see Frio Fresh, don't know who he is, don't know anything about him. Once they find out it's Averyk Carrasquillo, they have absolutely no reason to suspect that he's involved in any kind of crime, except for the fact that he had an old gun case when he was younger that he had served his time on.
So
That's exactly the
has any
situation.
court imposed this prerequisite on the police for ruses?
I think that there has to be some, maybe it doesn't have to be him. Maybe he.
I'm
was friends with somebody else.
certainly going to read you a favor as you cited, but nobody's done that, correct?
No, I don't think that there is a case directly on this point. I think this is something that you could look at under Article 14, because I think that there has to be some suspicion, because otherwise the ruse is just, especially when you use technology for it, it's just a matter of sitting there and waiting for somebody to commit a crime if they in fact do it, and with almost no police resources.
Well, now, counsel, what if an undercover police officer decided to go sit in the Boston Common on a bench and wait, and eventually somebody came up and said, you want to buy some drugs?
Well, Your Honor, that would be different.
Why?
Because I don't believe this, again, is a private account. So if you're not accepting the premise that this is a private account, then your analogy is apt. But if you accept the premise that this was in fact a private account where he at least had some role of letting people in and out, it doesn't have to be a highly scrutinized role, but some role of letting people in and out, then the people who he's letting in and out have to actually be people to whom he really consents to. That is very different than sitting on Boston.
Is it very different? You've got somebody who has about 100 followers, sends out a Snapchat to people, including people who he doesn't know, who he's let in. And every one of those people can take a screenshot of that Snapchat. And in Delgado Rivera, the police went and took the phone.
Mm-hmm.
Here, they're receiving the information. There, they took it. Here, they're just receiving.
Well, Your Honor, I would say to that, number one, he's sending it to all of those people. And if one of those people brought it to the police, we'd be in a different situation. That would be closer. Or if the police, like I said, had a search warrant for one of those other people's phones and they saw the Snapchat, that would be like Delgado Rivera. But here, the question is, the police officer became one of those friends by seeking consent. And I think that makes it, sorry, I lost my train of thought here. It makes it somewhat different because, I know that there's a problem with crediting Mr. Carrasquillo, and the judge said, well, I don't know if he knew who he was really friending, but you can look at it the other way. Why did he think this police officer was somebody he knew? What were the attributes that made him think that? So, you know, she ultimately ends up discrediting him because she's looking at it from the first prong. When if you look at it from the consent issue, why does he even think that this police officer, who incidentally isn't identifying himself as a police officer, and we don't know anything else about his profile, why did he think that this was somebody he knew?
Maybe he didn't.
And maybe he didn't, you know, but we don't have enough facts on this record. And it's the court is supposed to be able to scrutinize the record to figure out where that line is between consent and coercion. And you just don't know what happened here because we don't have the facts.
Can I ask just a distinguishing question? So the cops often pretend to be young children to identify people who are interested in kiddie porn or so, and they use social media to track that stuff down. So how do you distinguish the ruse, that ruse from this ruse? Because I take it they're just generally exploring out there.
It's hard for me to see who's
Yeah, sorry,
talking.
no, yeah, no, I'm sure.
I don't know that they're generally exploring because, Your Honor, I think those are different situations where they come upon a server that is sending out child pornography and then they're seeing who is actually attaching themselves to that server. I'm not saying the technology correctly at all. But there is actually suspicion there because the server hosting the child pornography in and of itself is criminal.
I think they're going more broadly than that. At least some of the cases we see, they're out on social media prowling around in the same way that this gang unit is monitoring things too. I'm not saying you're not right that there should be some guidance maybe, but I'm just not aware of any.
Well, I would just say that there is a factual distinction because if they are trying to inculcate themselves into the child pornography network, there's already fundamentally a problem there. And they're inculcating themselves into Mr. Carrasquillo's social media network. He's just some random guy. And that is a big distinction.
Okay, thank you very much.
Thank you, Your Honor.
Okay, Mr. McLean.
Good morning. May it please the court. Ian McLean on behalf of the Commonwealth, along with the assistant district attorney that handled the case at the trial level behind me, Caitlin Fitzgerald. Your Honors, this court should affirm the defendant's convictions because the defendant failed to meet either prong of his burden of establishing a reasonable expectation of privacy. The case is that simple. To begin with the subjective prong, the defendant offered his own testimony, which was expressly discredited. His testimony about the privacy settings he employed on his account and who the people he was.
We need to review the record to see if in fact it's supported or if it's clearly erroneous. But let's skip to objective.
Yes, Your Honor.
The nature and what's marketed, as I understand it, about Snapchat is it's ephemeral messaging as opposed to other means of social media. How does that not fit footnote 7 of Delgado Rivera?
Well, Your Honor, the features of the social media application that exists that were employed would feature into the analysis. As this court noted in Delgado Rivera, it's basically a totality of the circumstances test to evaluate what steps this person took to attempt to maintain any privacy.
Right, so he's not sending a video out on the Instagram. He's not putting it on Facebook. He's doing it on something that's meant to disappear. Now, whether it does, and people with more dexterous thumbs than me can screenshot, it's a different matter. But the marketing and the nature of Snapchat is it disappears, correct?
Correct, Your Honor. With 24, using this feature, the story feature, when you post an image or a video, it remains available to all of the people that you have friended for a 24-hour period. And for an unlimited number of times, they can access it in that 24-hour period. And I point you to transcript 14 for the discussion of the basic features of Snapchat in this record.
Let me go back to footnote 7 because.
Yeah, can I get the answer to that question? And
So, Your Honor, it is a factor that would be considered, but it is essentially almost no import here because once the image is sent out and the defendant has lost control of it to the recipient, they have unlimited access for 24 hours. They can show it to as many people on their own device as they want to. As I believe Your Honor pointed out during opposing counsel's argument, they can take a screenshot of it, they can record it, they can memorialize it themselves, they could then upload it anywhere to anyone in the world, almost exactly as this court noted with the text message in Delgado Rivera. Once the sender has lost control of the content to the recipient, they no longer have an objectively reasonable expectation of privacy. Here, because Snapchat allows that image or video to be available for 24 hours and an unlimited number of times for that recipient to access it, it's essentially the same. They've completely lost control of the content of the communication.
You've answered my question. Thank you. Just slowly.
I didn't know that. So when you send something out on Snapchat, I thought it did disappear, and the question left open in footnote 7 of Delgado Rivera, it's a question, not an answer, that we might have to address it. But I didn't understand that was the technology.
Your Honor, there are two different primary functions that Snapchat has. I could send, if you and I were friends on Snapchat, I could send you directly an image, and in the settings, I can determine how long that image will exist before it then disappears and is gone forever. I could set it as short as just a few seconds. But if I post something to what we commonly refer to as my story, meaning every person who I've friended can see it, it remains available for 24 hours. And every friend can access it as many times as they want to, unless I take the affirmative step of then deleting an image or a video from my story.
All right, I'm sorry that this is so far over my head, but do we know which one of those occurred in this case?
Your Honor, he was posting images to his story. And you can see that in the transcript at 14, where he's describing his, the officer's describing his understanding of how the Snapchat functions, how it works itself, and that he had to friend the person. And then once he were friended, at I believe it was 33, he indicated that he could see them for.
So if this thing was available for 24 hours and was readily savable, how come the cop couldn't do it?
Your Honor, I think you have a slight confusion about the facts here. There were two separate videos that were viewed. One was saved and actually introduced into evidence as Exhibit 1. That was the video that showed the defendant holding the gun itself. The second video that was observed is how the officers were able to think where he was because they recognized the background. That video was deleted before they were able to memorialize.
Was that a story or was that the second type?
Story.
But no, but
The second one.
the second
where they
snap.
recognized.
Yeah, that gave them the location. Was that a story or was it the other thing?
It's our understanding that it's a story, Your Honor, and that's because the officer testified that he never had any direct one-on-one communications with the defendant. So from that, we infer that because he was able to see it and he never had any direct communications, it had to have been a posting to the story. That the defendant must have, for some reason, chosen to enter his Snapchat application and take that video down. And that's why it didn't remain there for them to access it again to record it.
I should probably ask my children this instead of you, but if somebody sends a personal Snapchat to somebody else and they say that it's only good for a couple of seconds, those couple of seconds don't start until the person opens it up and gets a chance to look at it, right?
Correct, Your Honor.
Okay.
Correct, Your Honor.
Is this a different case with the couple second snap versus the story?
Respectfully, no, Your Honor. If the defendant had sent a Snapchat message to a direct friend, that person still has complete access over it. While the image shows up, it just takes a click of the phone to create a screenshot image of it, and then you have it permanently. So he's still lost control of the content. He would have taken an additional.
Well, how do
step.
you justify that answer in light of our jurisprudence under blood? I mean, at that point, he's just talking to somebody effectively in his home under Justice Gaziano's analysis.
Well, so Your Honor, in Delgado Rivera, we factor in all of the circumstances. So that certainly would be a circumstance that would be factored in. What specific function he was using within Snapchat and how he had altered the settings or what.
So your answer to Justice Gaziano's question is yes, it depends, not it's the same.
But my answer is sort of, Your Honor. My answer is it factors into the analysis because it's essentially.
Yeah, but it's loaded. You basically want all social media to be open to the police. If that's the case.
Your Honor, here it's social media that the defendant chose to friend an undercover officer to. So drawing an analogy to the line of ruse cases that someone.
So then we shouldn't have written the footnote 7 in Delgado Rivera.
I disagree with that as well, Your Honor. It is that the features of the device being used are something that could be factored into your analysis.
Yeah, but you want to factor it in, but it's a nothing burger under your analysis, right?
I guess I don't understand how one does not have a reasonable expectation of privacy on a direct message snap that one sends and deletes in a second. I mean, that seems like you're your definition of privacy is very narrow.
Once you've taken it down to a second, as the Commonwealth concedes, all of these things will be factored into the analysis and the totality of the circumstances. Once you've taken it down, setting down to a second, you're now much closer to the hypothetical you posted of it being essentially the equivalent of a communication, a direct.
All right, what if it's an hour?
But an hour would mean I could set the phone down, go for a walk, come back, and it would still be there available to me. So it would be so easy for a person to take a screen capture or take a video of it to memorialize it permanently.
But then you get into a real problem here, because if we're supposed to be providing guidance to the lower courts, where are we going to draw the line then?
Well, respectfully, Your Honor, it's a totality of the circumstance type test, as so many other legal tests exist.
Sure, but it could
evaluate on a fact by fact, on a case by case and fact by fact basis. Here, the defendant didn't do anything to maintain any semblance of privacy over his account. He was posting the videos we're talking about in this case to his story, making them available for 24 hours.
Let's assume for the sake of argument that he has demonstrated a subjective expectation of privacy. Can we go to whether that is reasonable in this day and age with the way social media is handled and the way people get into accounts? And why does anybody have an objectively reasonable expectation of privacy in any electronic communication?
Well, respectfully, Your Honor, employing the analysis this court just used in Delgado Rivera, it's once you've lost control over it. It's the same analysis that had been used, starting with letters, then through packages, then emails, phone calls, text messages most recently. You have the expectation while you still control the information. Then while it's in transit, was a letter or a package as UPS is shipping it.
Well, but those are covered by federal regulation. Letters are covered by the mail laws.
Yes, Your Honor, but the reasonable expectation of privacy analysis is still the same. We recognize a reasonable expectation of privacy while the information or the content of the package is sealed and in transit. But once the recipient receives it, the sender has lost all control over it. And then that basically means your initial subjective expectation is no longer objectively reasonable, because as the recipient, I can disseminate it to anyone. When we get down to using a tool that would only make the information available for a second or a fraction of a second, you're much closer then to a one-to-one communication. But again, that's not what happened here. He sent videos that were available for a 24-hour period to every one of his people on his friends list. And it's clear from the record, he was employing no real security protocol. So we're sort of in the realm of kind of like the D'Onofrio case from quite a while ago, where it was a private club that had a policy about security measures. But just because they had a policy doesn't mean they were actually employing it, which essentially meant the doors are open to our business, which is basically what the defendant did here. Someone sent him a friend request and he just accepted the friend request and then voluntarily chose to send them information. When he did that, when he voluntarily sent them the information, he lost control over the information.
Now, counsel, could you answer, because you brought up the D'Onofrio case, your sister's argument about, but at least in that case, they had a suspicion of criminal activity that they were investigating. This isn't that. There was no indication here that the defendant had been involved in any criminal activity when the friend request was made, when the ruse was employed.
Correct, Ron. And there doesn't need to be. An undercover officer could, in Boston Common, dress himself with the appearance of what he thinks a typical drug user looks like and randomly approach people in Boston Common to see if they're willing to sell him drugs or not. He doesn't have to have even a reasonable suspicion to engage in a voluntary encounter with the citizen somewhere. That's basically what happened here.
Well, not really, because in that case, the police officer's kind of creating it, right? Because you're going and you're affirmatively asking, do you have drugs to sell? In this case, the point I was making that your counsel referenced, going back and saying, you can just sit back and watch, right? You employ the ruse, you have no suspicion of any criminal activity, but now you get into Mora, right? Where you're just sitting back and just waiting for somebody to step in it.
Well, I two responses, Your Honor. First, I'd say it's categorically different than Mora, where it's surreptitiously recording everything that you're doing. Or in Mora, it was the outside of your house, so who's coming and going, when they're coming and going, interfering with your associations. Here, the only information that they're accessing is what the defendant himself is voluntarily choosing to send directly to them. So it's categorically different from Mora in that regard. Second response would loop in Justice Kafker's point about the to catch a predator type of cases, where an undercover officer will pose as a minor or a child and then work their way into communication networks. In the older days when I worked those cases at the U.S. Attorney's Office, it was message boards they were communicating on. I'm not current with how they're doing it now, but they must be using tools like Snapchat, Facebook, other social media applications to work themselves into these communication networks to see who then they should be taking a closer look at. It's basically the same activity here.
This gets more concerning. The breadth of this is what seems to be worrisome. So under your approach, and I get that cops are doing this to detect porn and other things, particularly kiddie porn and other things, but you're basically saying that they can just go out on social media and go exploring. Any public, and you may be right, but it is concerning that they can just basically look through everyone's social media accounts, particularly any public aspects of those media accounts, and sort of, basically go hunting. Is that right? Because you're essentially saying they can do that, right?
Yes, Your Honor. Just as any law enforcement officer can have a voluntary encounter with any citizen on any street corner.
It's a little different though when we're talking about social media, which is, as basically the Supreme Court says in Carpenter, our whole lives are out on social media, right? And so the police now have, I'm not saying they can't do this, but it's concerning that they have complete access to this unlimited amount of social media for all of us, right?
No, Your Honor, and I disagree with the analogy to Carpenter and the cell phones becoming an appendage and an essential part of modern life. You can use social media here without friending unknown people.
Right.
Just as you can allow people into your house and exclude unknown people. And as that would be completely permissible in the context of a house, which we consider first among equals for privacy protections, you can't afford more protections to someone's social media than to the front door of their house.
Right, I know, but the problem we have is that our social media is revealing of our personal lives as our house is at this point. So it gets tricky.
Only what you choose or volunteer to put out there.
Right, I get you.
You can participate in modern life as I do without being a participant on social media networks. That's a choice that someone has made, just as you would make a choice when someone knocks on your front door, whether to let them in or not. The check that you employ there at your front door is listening to their voice. Do you recognize the voice? Looking through the people, do you recognize the person? Do you want to let them in or not? That's employing some level of security, and the burden or the onus is on the person in their house. In the social media context, you still have to employ some level of security, some level of check. If you just let anybody in who solicits, you have an open door policy and they can view whatever you choose to put out there into the world, and you vitiated any objectively reasonable expectation of privacy.
Mr. McLean, if we get past the subjective expectation of privacy here and we're looking at the objective, do we need to address the defendant's argument, property-based argument?
No, Your Honor. There's no property interest in the content of the communication once you have sent it out to 100 people with their ability to have complete and unfettered access to it for 24 hours, to duplicate it in any way they choose, and to send it on to anyone they choose to. You've lost any even arguable property interest that you would have, which in part is through the ability to exercise exclusive dominion and control. And you've given that up. Part and parcel with losing control over it, just as the text message in Delgado Rivera.
Can I ask you one last question for me anyway? When do we measure the reasonable expectation of privacy and the consent issue? Is it with each story post? Did I have a reasonable expectation of privacy in that post? Or is it vis-a-vis the account? Because it seems like we're all talking about the account. But each time one posts a story on Snapchat, you make a choice as to who you send it to. It sounds like you can directly snap a person for a particular period of time, but then you can also snap, everybody you're friends with, and you can also unfriend people, right? So each time you post something, there's a choice that you're making as the user of Snapchat. Is that when we measure the reasonable expectation of privacy, or is it vis-a-vis the account as a whole once set up?
But Your Honor, I think under Delgado Rivera, it's totality of the circumstances. So you'd have to factor in the ability to change your privacy settings on every individual interaction. So as the defendant testified to, the officer did not, but the defendant testified, you can make a choice for each individual post, whether it's going to be publicly available to the world or available only to your friend group, or whether it's going to be a direct one-to-one communication. So it's going to be on a case-by-case basis and what a defendant is trying to suppress. Because it could be a case where some of the things they sent out, they sent to the entire world writ large. Some of the things they sent were just to their friend group. Some of the things were a direct one-to-one communication. So there'd be a different analysis for each one. So I think the answer has to be a case-by-case analysis of what we're talking about here. Now, as to when we conduct the analysis about the ruse, Your Honor, that would be when it occurred. Just as an undercover officer knocking on your front door and asking to come in to buy some drugs, you conduct the analysis right then about the defendant giving the undercover officer access to the house. And then what the undercover officer sees or does inside the house will be evaluated separately. There are no further questions?
Thank you very much. We'll take our morning break.
All right.